And good afternoon, good evening, and good night, and welcome to today's episode of Law, News, and Laughter. I am, of course, running apocalyptically late because I was up late with Jeff going through the Amber Heard stuff. But, you know, 'tis what it is. I wasn't actually sure if I'd do a stream today, and then I saw what dropped with Murdaugh. And I got copies. I don't know if they're legit because I haven't actually managed to get them from a court source, but we're going to have a look at the affidavits that are attached to the stay motion. Beyond that, a good friend of the show, Mr. Stephen Gosney, dropped me a link to a death penalty murder case that is coming up. Jury selection was today, so we're going to check if that is something that we want to follow, whether or not we should all of a sudden drop everything and watch a murder trial. So we'll see how we feel about that. We may or may not have a guest dropping by, which is great. In the meantime, let's get stuck into it, shall we, people? Welcome to Law, News, and Laughter. I have absolutely no idea where my phone is because I just felt it vibrating, but there it is. Okay. All right. So this, I've done a little bit of looking into it because, let's face it, you have to see what you can find on Twitter, on news sources, all that sort of stuff. If this is legit, the fact that certain people on Twitter are trying to sweep it under the rug or acting like it doesn't matter even remotely, that's a big thing to me, especially given that it's supposedly someone that was very intrinsically linked in the case. I mean, it was the freaking court clerk, and yes, I'm going to try my hardest not to swear. But let's get stuck into it, shall we? All right. Alex Murdaugh's lawyers want a new trial. They say the court clerk told jurors not to trust him. Attorneys for convicted murderer Alex Murdaugh want a new trial, accusing the court clerk of improperly influencing the jury and betraying her oath of office for money and fame. It certainly feels a little bit like that. What's that? Congrats, you've had the goatee long enough that you look funny without it. People keep calling me DSP, but aside from that, they've accused the court clerk of his double murder trial of telling jurors not to trust him when he testified in his own defense, having private conversations with a jury foreperson, and pressuring jurors to come to a quick verdict. And may or may not have handed out business cards for the reporters and suggested that they all do interviews. But we'll get to that. The request filed by Murdaugh's lawyers on Tuesday also accused Rebecca Hill, Colton County Clerk of the Court, of giving jury members business cards from reporters during the trial. After the verdict, she travelled to New York City with 3 of the jurors to do interviews. She also wrote a book after the trial called Behind the Doors of Justice, The Murdaugh Murders. That's bad. The trial clerks aren't someone who should even talk to them about the case. I've never heard of that, said attorney Dick Harpootlian, a state senator and lawyer of 50 years. Hill did not respond on Tuesday to requests from the Associated Press for comment on the filings. Prosecutors said that they're reviewing the motion and would respond through the courts. Well, duh. They probably thought this was long buried, and that they'd just be looking at it in appeals. Thanks, Mr. Kagriff. I've got the motion and the affidavits. Maybe if you can compare them when I bring them up, just because I haven't verified the source as of yet. So, although I'm looking through the documents, they look legitimate, but I did not have time to go through my usual fact-checking sources. Cops violate their oath every single day. Same with court officials. None of them actually know the words of their oath in the first place. Nice, Jason. Oh, there it is. Almost forgot the energy drink. There we go. At some point, I'm going to get a V sponsorship. Murdaugh wants the appellate judges to order an evidentiary hearing, and once they have more information on the record, to grant him a new trial. If the affidavits are legitimate, there is, in my opinion, sufficient cause for a retrial. 65 pages. Yep. Okay. The 55-year-old disbarred attorney is serving life without parole after being convicted in the shooting deaths of his wife and son. Sorry, just gotta... Yep, okay. Murdaugh attorney Jim Griffin said everyone the defense tried to talk to refused to respond until Hill's self-published book came out. Only then did a few reluctant jurors answer the door as Harpootlian's team made another round of in-person visits on weekends. Well, I mean, firstly, dick. That's a dick move. Trying to meet with witnesses on the weekend. But that's just my own personal opinion. I mean, you're supposed to try and organise that stuff during business hours and properly compensate the witnesses for it. There we go. There's my face nice and big again. The hearing would enable defence attorneys to force the other jurors, witnesses, and potentially even the trial judge to testify under oath. I haven't really hid any of my disdain for the way that trial was run, to the point that legitimately, there have been a couple of other South Carolina cases where I've wanted to watch them, and I've decided against it because I do not trust that judge to run a proper trial, unbiased. Verdict was a crock, don't get me wrong, he is scum, but the evidence was rubbish. Absolutely. Oh, hello. Give me 1 second, peeps. Just let me fix this up. You want a second? All right. We got someone waiting in the wings. All right, where are we? The defense could also get phone records, emails, and texts. Right now, they have what Harpootlian's team gathered by visiting jurors' homes. We have nothing but Dick's Mercedes and dirt roads in Colton County, Griffin said at a news conference outside the State Court of Appeals. You good? All right. Welcoming to the stage, Mr. Andrew Branca. Sorry. How you doing, buddy? Oh.
Well, happy to be here. Thanks for having me, man. I appreciate it.
No worries. It's always good to be able to have someone that's available during the day. So, what do you make of this? I mean, this is a court clerk that supposedly influenced jurors, and we've got affidavits from 2 separate jurors and a third individual basically saying, yeah, not only did she speak to the jurors, she told them to try and find the verdict in a specific way, and then push them to go and do publicity.
Yeah, so she should be charged and prosecuted and convicted, and her sentence should be the life sentence that Alec Murdaugh got.
I wholeheartedly agree with everything about that. I don't see this as any different, really, to when we'll say a male or a female makes an allegation against an individual that gets them incarcerated on false pretenses. It's the same as crying grape, but they're not actually anything having taken place, and it's provable. So I'm always very big on, if you do that to somebody and ruin their life in that manner. I mean, don't get me wrong, I still think he was probably involved, if he didn't do it. I do not think it was proven during that trial, though.
What's involved mean, though? I mean, this is a dirty guy, right? Alec Murdaugh deserves to spend the rest of his life in prison, if only for all the money he stole from all those people. He's not a good guy. He's a shitbag. I have no trouble with him being in prison. But that's not the legal question here. The legal question is, did he murder his wife and son? Now, is it possible that the drug dealers he was involved in murdered his wife and son, and he's involved tangentially? I mean, in that sense. But that's not a responsibility for the murders. He didn't want... No one will ever convince me that Alec Murdaugh, when every state witness in a position to know testified that he loved and adored his wife and son, that he murdered them. I just don't believe it.
No. I honestly think
now,
that's
did the shit he got himself involved in end up in their death? Yeah, probably. I mean, I don't think it's independent of that. The fact that the girl was killed on the boat, the fact that he was involved with serious drug dealers, people die in those environments. So in that sense, he probably had some moral culpability. But did he actually play an active role in the death of his wife and son? I just don't believe it. And we have more reason than ever. Now, I mean, we had reason to doubt it during the trial, right? Mm-hmm. The last moment his wife's phone moved, according to the state data, he was half a mile away from that location. We have testimony from the SLED chief investigator saying he perjured himself to the grand jury to get the indictment. He fabricated evidence. And then we had days or weeks, I forget now, many days at least, of testimony about his various financial crimes, which had nothing to do with the murder of his wife and son.
Nope. It was all just to get all that out there on the record so that they could...
in there.
Yeah.
So to me, there was always more than, you're not supposed to be convicted in America unless the jury is convinced beyond any reasonable doubt that you convinced the crime. And to me, there was plenty of reasonable doubt throughout this trial. And now we find out that the court clerk told the jurors, according to affidavits that the defense has, to don't pay any attention to Alec Murdaugh's testimony. He's a liar. Well, in American law, I'm not sure how you do it in Australia, but in American law, if someone's going to testify against us in a criminal trial, we have a right of confrontation. We have a right of cross-examination. We get to put that person to the test. That is in our U.S. federal constitution. That's how important a privilege it is. And of course, the clerk went completely around that, while, by the way, she had a contract to sell a book about the trial. So she had a personal financial incentive.
It's just, it's honestly insane. Okay, where did I get to? The defense has talked to 4 jurors and included sworn statements from 2 of them. A lawyer for the jurors, Joe McCulloch, was at the news conference and said they came forward reluctantly but didn't want to talk about their motivation or what they thought about murder. Yeah, probably because they like everybody else, they think he did it, but this is more about the court process, which is really what it is. As you said, he most certainly deserves to be behind bars.
Right, but it's not hard to imagine that, you or I or someone we care about could be charged with the murder and not have the financial complications, right? And we wouldn't want to be treated in this way.
No, of course not. Irrespective of how much of a scumbag he is, it's always a case of you have to treat your worst enemy as you would want to be treated in court. So they have to be given every benefit of the doubt, every proper procedural fairness.
Because the procedure he gets is the
same procedure that everyone
gets.
Your
loved one gets, your children gets, your wife gets. And if you're going to shortchange him, guess what's going to happen to you?
Exactly. The request for a new trial centers on Hill, who was elected court of the clerk in 2020. Hill had private conversations with the jury foreperson, both inside the courthouse and when jurors visited the crime scene at the Murdaugh's property. What is it usual for the court of the clerk to attend on site visits like that?
I mean, I wouldn't say it's unusual. By the way, I should make clear that the real problem here is not that the clerk was talking to the jurors. In American courts, the clerks talk to the jurors all the time because the clerk is the one who arranges for their lunch, for their cigarette breaks, for if they need a restroom stop. So the clerk's always talking to the jurors. That's harmless when it's about inconsequential matters. What the clerk is not supposed to talk to the jury about are any material facts about the case. Don't believe this evidence. Believe that evidence. That is completely verboten. So the fact that the clerk was talking to the jurors is not in and of itself a problem. It's the fact that these affidavits swear under oath that she was talking to them about material facts in the case, not just lunch or restrooms or smoke breaks.
Paulson Sanders saying, I wonder how they're taking this over at Law and Cuck. Not well from what I'd seen this morning. some of the Twitter threads and that sort of thing. Yeah, people are either saying we should completely disregard it, or they're saying it won't change the outcome. Which, look, there's a good chance it probably won't change the outcome, but again, it's procedural fairness.
So in American law, if there's some kind of factual dispute, the appellate courts look at it, they might ask themselves, well, would this have been more likely than not to have changed the verdict? And if not, then we're going to leave the verdict the way it is. So it's kind of a preponderance of the evidence standard. When it comes to this potential witness jury tampering by the clerk, the legal standard is there is no threshold. Did she talk about material facts with the jury? Period. If she did, it's presumed to have been prejudicial to the defendant, and it's a new trial. That's how important we consider it.
Yeah, and that's exactly where it should be. Where are we? The filing did not include any statement from the foreperson. That I find interesting, given that someone specified that they had conversations directly with the foreperson. Do you think maybe that's just because the foreperson feels like they're going to get in a little bit of extra trouble if that comes out? Or
no, they won't. But the foreperson, it tends to be a self-nominated person, so they're kind of an alpha in the group of jurors. The introverts don't tend to be the 4 people on a jury, and they may have held up their hand to be the foreperson because they were super emotionally committed to finding this guy guilty. And now they don't want to be questioned about any discrepancy in that verdict.
No, fair enough. The jurors told Murdaugh's lawyers that Hill told them not to be fooled by the evidence presented by the defense and to watch Murdaugh closely as he testified and to look at his actions and look at his movements. One juror said they understood it to mean that Murdaugh was guilty. So there's enough of an implication from her conduct that she was saying, yes, this guy's guilty as sin, and you guys need to find it that way based on watching him.
And she's an elected government official. She's not just an employee of the court. She doesn't work for the judge. She ran for independent election, got voted for by the populace. So she's acting under color of law as a government official. And how much personal knowledge does she have about these killings? Zero. But she's used, because she wasn't there. She doesn't know anything. She's a court clerk. But she's trying to influence these jurors to a guilty verdict based on her personal opinion about the matter. That is about as egregious as you can possibly get. If she wants to state that opinion, let her take the witness stand and be subject to cross-examination, and let's see how that works out.
Well, from the sounds of it, she's going to be now. So,
yeah, but she'll plead the fifth on the stand now.
Oh, absolutely.
I mean, she's almost certainly facing multiple felony charges.
All right. The appeal also says Hill lied to the judge during the 6-week trial about a Facebook post that led to the dismissal of a juror. Now, this one's interesting because they're saying that she lied to the judge about this. So the ex-husband of one of the jurors purportedly posted something on Facebook about the trial and whatnot, and that it was in direct. The juror had been in direct contact with her ex-husband and that sort of thing. The jurors said that she hadn't been in contact with her ex-husband for 10 years.
Right.
And so...
And there's all the evidence suggests that these Facebook posts were a fabrication of the court clerk. So not only did she jury tamper, a felony, she's
falsifying evidence.
A felony. In a murder trial.
Yep. Posted that she was talking about the case and about what the verdict would be. Hill never presented the post, only showing the judge an apology from what she said was the ex-husband's account. But the apology post did not come from the ex-husband's account, and the defense said the analysis of his Facebook account shows he had not made any posts that day.
Right, so where we are right now is the defense has some affidavits from jurors saying she influenced us, basically. And they're using those to request a hearing, evidentiary hearing, to further explore what might have happened here. And then the judge, by the way, it's the same judge as the trial judge, it's Judge Newman all over again. But if he grants the hearing, suddenly now the defense has subpoena power of the court. So they can go subpoena these jurors, the jurors who don't want to talk to them right now. Guess what? You're subpoenaed, you're coming to court, you're going to testify under oath. Your phone records, we got them. Your computers, we got them. You faked that Facebook bullshit you're talking about, we're going to find out right now because we have subpoena power, we can grab all that stuff once the hearing is granted.
What do you think the odds are that Newman turns around and says, no, I don't believe that this is sufficient enough? I mean, I think it would be career suicide to do so, but...
I don't know. I mean, listen, I don't think he was honest in the trial. I think he was very biased in the trial. I think letting in all those days, if not weeks, of financial misdiscretions by Alec Murdaugh, which should put him in jail for the rest of his life. He stole from everybody. He's a shitbag. The guy's a shitbag. But that's not the legal question here. The legal question here is, did he kill his wife and his son? So it's a distinct legal question. By blending in the other bad acts that he committed, I think you end up with fruit of the poisonous tree. I think everything is toxified. It should never have been admitted. The prosecution's argument that, well, he killed his wife and son to delay for a week the discovery of his financial crimes is ludicrous when every state witness in a position to know said he loved and adored his wife and son. It's nonsense that someone would kill people he loved and adored to get a week delay in the inevitable disclosure of his other misdoings. So I don't know what's motivating Judge Newman. I can't read his mind, but objectively observing his decisions to allow in witness after witness after witness to talk about these financial crimes, it just didn't strike me as objective.
No, to me, it felt like he had to have personally known someone that had been robbed, basically, that had lost finances to Alec. And it's like, at what point, I mean, with how widespread the financial crime and that sort of thing was, there's no way in hell this trial should have ever been located where it was. Like the whole thing to move the trial should have been granted, but no, he was absolutely not objecting.
Moved where? See, the
Yeah, that's
trouble
the
is
problem.
in America, it's very difficult to get trials moved. It's almost impossible. So you can make the request, but then what always comes up, and this happened in the Rittenhouse trial, many other trials, is they ask, well, where would you move it? Because when the trials become high profile enough, so in America, unless it's a federal court case, you're in state court. So it's going to happen within the boundaries, the borders of the state. And
Yes.
if the case is high profile enough, there's nobody in the state who doesn't know it.
That isn't going to be poisoned by the media about it. Yeah.
Right. You're going to move it to another county. I mean, it's not like they don't know about it. They read the same social media we all read.
Well, so I agree with that. I do think that maybe even if you move it to a county that is poisoned by the media, it's still better than it being poisoned directly by his actions. I mean, I think given this was so widespread, I think taking out the immediate personal influence of it, I think would probably be better if you are, even if it is, yeah, okay, everyone reckons that he did it or whatever. It's still better than him being tried by people that have been directly impacted or their neighbor has been directly impacted by it.
Or even indirectly impacted. Listen, we have to understand human drivers here, right? So here's Alec Murdaugh. He's got a beach house. He's got a city house. He's got a country house. He's got hundreds of acres of hunting ground where his sons, with their boats and their pretty girlfriends and their money, and they drive around in ATVs and everyone's having a great old time. And then they find out this guy stole all of that. He didn't earn it. He stole it. They're going to hold that guy in the worst contempt possible. He was living over them out of criminal activity for stealing it. So they're going to hate that because they're watching him. They see his beach house. They see the boat. They hear about the tragic accident where his son was driving the boat and the girl died. Well, he has a boat. You know how many people in that county in South Carolina have a boat? It's poor. Nobody has a goddamn boat. No one has 1,800 acres of private hunting land. These things are unheard of except for the elite wealthy. But what happens when you find out that the prince in your county is just a crook? He's not really a prince. He just stole that title.
Oh, tall poppy syndrome kicks into the nth degree and you want to watch him burn.
Of course. So they should definitely move him from have moved the trial for that reason alone. But I would go even further. Because I've had this come up before, like the Rittenhouse trial, other trials. And my position is, if the state says it doesn't matter where we move him, we can't give him a fair trial, it won't be any different. My position is you cannot try that person. You cannot try him. If the environment is such that he cannot get a fair and impartial jury, you cannot try him.
I've often felt along those lines as well. I do wonder at what point
I understand. We live in a social media era, right? So the news goes everywhere. So it's not hard to imagine that, in fact, there would be no place you could get a fair and impartial jury. But to me, I value the due process due to the defendant higher than I do the interests of the prosecution.
Yeah, no, I completely understand that. More for me, it's balancing the rights of the witnesses, of the victims, families, that sort of thing. I mean, I don't think you can indefinitely put off someone's prosecution because they can't receive a fair trial. I think after a certain point, because they're competing interests.
If you can't give a fair trial, can you try them in an unfair way? Is that due process of law? Hey, we can't give you a fair trial, but we have an unfair trial right here, so we're going to give you that one.
Look, it's not a perfect system. We know this.
So, of course, I'm a criminal defense attorney, so I'm always biased in favor of the defendant. I think the prosecution should be held to the most rigorous rules imaginable, and the defense should be allowed to get away with whatever they can get away with, including this. Now, is that a personal, professional bias on my part? Sure.
But I mean, if
but you'd like me to be your attorney.
Yeah, hey, I got no problems with that. Okay, so hypothetically, if there was a case where an individual could not receive a fair trial, though, and that it was in relation to murder or some sort of heinous crime, what would you think the options there would be? I mean, would you have him...
I think the burden's on the state to provide a fair trial. They need to do whatever they need to do. Find people from Alaska to be on the jury. I don't care what they have to do. but they have to find people who are genuinely do not have a preconceived notion about the guilt or innocence of this defendant before they hear testimony in trial.
Okay, but I mean, how long would you say that an individual should be held in remand until it gets to a point of ridiculousness where either?
No, I mean the state has to do that you have a right to a speedy trial in America, so they can't delay indefinitely. So I mean, it's common for weeks or months to go by. So if it takes them, I don't know, 3 months, 6 months in a murder trial, we get into a lot of complicated issues, like how much probable cause do they really have to lock someone in jail without bail? This guy can't work. He can't support his family. Those are different issues. But within the normal time frame of a few months, the state should have to prove that they have put together a legitimately unbiased jury in order to try that defendant. And if they can't do that, we have a constitutional right to an unbiased jury. If the state cannot meet that obligation, they ought not be able to put me on trial in front of a biased jury.
That's true. And Pawson Thunder was asking about a bench trial. Well, we've still got the right to trial by our peers. So if, I mean, no, could you imagine if Alec had waived the right to a jury trial on this one? I mean, I don't even know that you can
Judge
do that.
Newman would have convicted him instantly. But
exactly.
In America, it's a little more complicated because, of course, we have a state-by-state basis. So in some states, it's absolutely up to the defendant whether he gets a jury or a bench trial. A bench trial is a trial where the judge plays the role of the jury, so is the finder of fact. But in most American states, the prosecution also has the privilege to demand a jury trial.
Oh, really?
So it's not just up to the defendant.
Huh. Okay. All right. What did I get to? Post the apology. Filed the transcript from a closed-door meeting over the juror where Judge Clifton Newman said, "I'm not too pleased about the clerk interrogating a juror as opposed to coming to me and bringing it to me." So he knew during part of the trial that she had interacted directly with
everybody knew
one of the jurors.
It was right in the courtroom. So the defense attorney saw it, the judge saw it. But again, if she was talking about, hey, where do you guys want to go for lunch? That would be innocuous. It's not until you know that she was talking about material facts in the case that it becomes misconduct.
Yeah. Okay. Okay. As the jury began deliberating late in the afternoon of March 2, Hill said they'd been taken to a hotel if they didn't reach a verdict by 11 p.m., upsetting jurors who didn't pack for an overnight stay. Well, that's kind of lack of foresight on the jurors' part, but anyway. Some jurors said Hill also told smokers on the jury that they couldn't take a cigarette break until they reached a verdict. "You want nicotine, you're going to have to return a verdict form," Harp Hootley said. Whoa.
Now, Aussie, I don't know. Have you ever smoked?
No.
Okay. All right. So I haven't smoked in, 15 years, but I smoked for 25 years. Pack-a-day smoker for 25 years. I can tell you, if you take a nicotine addict, as I was, and you strip him of his nicotine, that is not a rational person anymore. And no one would want a drug addict going through withdrawals, which is what a habitual smoker who doesn't have his nicotine is doing. Nobody would want a drug addict going through withdrawals being his juror.
No, of course not. Sorry, just got a work call.
By the way, smoking's bad. Don't do it, folks. Kids, don't smoke. It's bad for you, and it's very expensive.
Okay, all right. After less than 3 hours in the jury room following the 6-week trial, they were unanimous, convicting Murdaugh on 2 counts of first-degree murder. Yeah, I think the nicotine withdrawal may have something to play into that. That sounds about right, actually.
I mean, just imagine, hypothetically, that it turns out that the jurors were all, this is 6 of them, so half the jury. Imagine half the jury were heroin addicts. And you told them, by the way, we've been giving you heroin throughout the entire trial, but now that you're going into deliberations, no more heroin until you return a verdict. Sound reasonable to anybody?
Oh, good God. I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by other jurors, said juror 630, who wrote in the sworn statement, adding that Hill pressured the juries to talk to reporters after the trial. The appeal redacts their names, identifying them only by their numbers from the trial. The final pages of the 65-page appeal cite a contract between Hill and a production company with a handwritten note supposedly from Hill saying that in exchange for her appearance, they had to show the cover of her book in their production.
All right. So just first of all, to me, it's As an American lawyer, it's ridiculous that a court clerk would be writing a book. It's like the stenographer is writing a book or one of the bailiffs is writing a book. What do they know about the inside workings of the trial? But in any case, even if it's possible to imagine, it should be unimaginable for someone in that position, an elected official as a court clerk, to be writing books about the trials in her courtroom. She has official duties in that courtroom.
It's insane. I mean, just it almost like just for the audience. I know it's not the correct terminology, Andrew, but it's almost as if she has a fiduciary duty herself to the court to make sure that she's not encouraging her own bias, and she has blown that out of the water.
Right. By having a personal financial incentive. By the way, if she's charged and convicted, as she should be, of these felonies of witness tampering, she should also, the fact that she had a personal financial stake in the outcome should be an aggravating factor in her sentencing.
Mm-hmm.
It wasn't just a whim or an emotion. She was making money, and she was going to make more money if he was found guilty than if he was acquitted.
Mm-hmm. South Carolina law sets a high bar to overturn a jury verdict. Murdaugh's lawyers said Hill's conduct was so egregious it tainted the entire trial, and they had no chance to defend against it. I think that's entirely reasonable for them to say that.
Yep.
She asked jurors about their opinions about his guilt or innocence. She instructed them not to believe evidence presented in his defense, including his own testimony. She lied to the judge to remove a juror she believed might not vote guilty, and she pressured jurors to reach a guilty verdict quickly so she could profit from it. Murdaugh's lawyers also sent a letter to federal prosecutors asking them to have the FBI step in to investigate, because the state law enforcement division, which is the lead agency for the prosecution, has a vested interest in maintaining his conviction. Not that I would necessarily trust the FBI to do their job here, but that's probably, it's better than having SLED reinvestigate it.
The problem is we're running out of law enforcement.
Mm-hmm.
So this happened in a state jurisdiction. It happened in a county within South Carolina. So there's a county sheriff. They didn't want to use him because he had ties to Alec Murdaugh. Fair enough. So then they go to the state level law enforcement, which is SLED. Their chief investigator confessed on the witness stand that he perjured himself in front of the grand jury to get the indictment and fabricated evidence. By the way, that guy was just made SLED Law Enforcement Officer of the Year in South Carolina. So that's how he got punished for that misconduct. But once you get past SLED, that's the highest level of law enforcement in the state of South Carolina. So if you're going to go beyond that, you have to go to the federal level. And the only federal law enforcement agency that would be applicable would be the FBI. And no, I wouldn't trust them either.
I mean, it's like for the regular viewers, I've talked about exactly how bad SLED is in other cases. I mean, there was an instance where they deliberately ran around a judge's order not to destroy a hemp crop. And basically they went through...
Oops.
Well, it's not only that. They lied to another judge, ignored the previous judge's order, lied to another judge, got an order saying that it was okay, and then it was... And now the farmer is going to have to go and sue them over it. And there's not going to be any repercussions from that. They're just happy to end run around when they don't get the result that they want, which I think we're seeing an example of it here as well. Even if Murdaugh's murder conviction is overturned, God, that's difficult to say, he likely will stay in prison. He filed papers in federal court saying he plans to plead guilty to stealing from clients and his law firm later this month, charges that would likely mean years, if not decades, behind bars.
Right, and he's 50-something, so decades is a life sentence, effectively. And by the way, he confessed to all the financial crimes when he testified in the murder trial. He just said, yeah, I stole all the money. I stole all of it. So, yeah,
there was next to no... Excuse me. There was next to no reason for the finances to be in there. I mean, given that he testified and admitted to everything, and he already knew he was pleading guilty because they've got him dead to rights on that. It was just a bad call to deal with all of that financial stuff over and over again for however many days. Okay, so what I have pulled is the letter that was sent to the United States Attorney for the District of South Carolina referring to them, and then I'm going to have a quick look through the affidavits. The motion itself is 65 pages. I'm not going through that in its entirety. I will look at the affidavits, just because that's where the real meat and potatoes is. I just want to quickly read through this letter. Honourable Adair Ford Burrows. On March 1, 2023, after a 6-week trial in Colleton County, my client Richard Alexander Murdaugh was convicted of the murder of his wife Maggie and son Paul. I write to request an urgent federal investigation of the conduct by the South Carolina elected official during the trial. I have attached his recent filing in the South Carolina Court of Appeals regarding this matter, which describes jury tampering by the clerk of the court for Colleton County, Rebecca Hill. Ms. Hill's conduct, described in detail by jurors in sworn affidavit testimony, implicates... I want to make sure I get this right. Is that Title 18, Section 242? Sorry.
Sorry, I can't really see it, but that's the normal nomenclature for a federal law statute.
Oh, good. Okay.
So USC would be U.S. Code. So Title 18, U.S. Code, Section 242.
Okay, all right. Which imposes criminal penalties on any person acting under colour of any law, statute, ordinance, regulation, or custom, willfully subjects any person to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States. Ms. Hill acted under colour of South Carolina law. She is the elected clerk of the court charged with jury management. See the various sections. Clerk of the Court Manual, Chapter 4, 2014. Every interaction she had with any juror during the murder trial was under the pretense of authority granted by state law. In our recent court filing, we assert that Ms. Hill's actions deprived Mr. Murdaugh of his rights under the Constitution. We believe that the statements...
A lot of these statutes were followed on the tails of the end of slavery in America, where you had the southern states. They weren't happy. They lost their slaves. They were all Democrats, of course. And they would use their official government positions to still deny freed slaves their civil rights. So we created these laws that say, hey, if you denied a freed slave his color rights and you're a government officer, we're going to hold you especially accountable. That's where these statutes come from.
Okay. All right. Believe the statements of state act are controlled by the command of the 6th Amendment made applicable to the states through the Due Process Clause of the 14th Amendment. Guarantees that the accused shall enjoy a right to a trial by an impartial jury and be confronted with the witnesses against him. As we said in Turner v. the State of Louisiana, the evidence developed against the defendant shall come from the witness stand in a public courtroom where there is a full judicial protection of the defendant's right to confrontation, of cross-examination, and of counsel. We have followed the undeviating rule that the rights of confrontation and cross-examination are among the fundamental requirements of a constitutionally fair trial.
Boom.
Yep. So that was from Parker and Gladen. I request that federal law enforcement investigate whether Miss Hill and any other state actor violated Title 18 U.S. Code Section 242 by tampering with the Colleton County jury. Even if no federal charges are ultimately brought, an investigation by Federal Bureau of Investigation agents is needed to discover the truth and to vindicate Mr. Murdaugh's federally guaranteed right to a fair trial. The professionalism and integrity of the FBI agents is impeachable. I couldn't even get through that. FBI agents will not attempt to direct the outcome of any investigation by pressuring or deceiving any juror or witness. No juror will attempt to deceive an FBI agent. If FBI agents interview the jurors, the truth will be known, whatever the truth may be. The same cannot be said of any investigation conducted by the South Carolina Law Enforcement Division, SLED, who has a vested interest in upholding his conviction. Mr. Murdaugh.
Right, so I'm not sure the defense counsel really trusts the FBI here either, but they're just trying to distrust SLED that it's got to be moved out of SLED.
Yeah. Mr. Murdaugh may be the most unpopular man in South Carolina right now. He has become a symbol of the low country judicial corruption. Disgust at his frauds, unfortunately, has created in some minds a but not Alex Murdaugh exception to the due process rights enjoyed by all Americans regardless of guilt or innocence. Those minds may delight in the irony that he may well be a victim of the corruption that he symbolizes. Federal law enforcement has long acted as a shield to prevent popular passions against a hated person from injuring the rights enjoyed by all persons. I ask that it do so again here. Signed, Dick Harpootlian. So they've formally requested an FBI investigation into the clerk of the court. She's going to be so butthurt by this. Where did the motion go? Like I said, I don't want to do the full 65 pages. Copy the motion of the trial. Hang on, I'll switch this across here and zoom this in. I love this. She betrayed her oath and office for money and fame. No shit, Sherlock.
It's a reasonable accusation. Let her answer to that. On the witness stand, under
Where's
oath.
the statement of facts?
I so want her to take the witness stand because, of course, the only reasonable thing she can do is actually plead the Fifth
Plead the
Amendment.
Fifth.
You know, but I want her to do it on the witness stand. Unfortunately, in America, we sometimes have judges where if they know that the witness is going to plead the Fifth, because it is an absolute right under American law to plead the Fifth, that they won't put him on the witness stand. So they just say, we know he's going to plead the Fifth, so we won't even swear him. And I want this bitch under oath on the witness stand. I want her to plead the Fifth under oath in front of other people.
Okay, I'll quickly read through the statement of facts because it'll cover over most of the stuff. Murdaugh was indicted for the murder of his wife Maggie and Paul on July 14, 2022. Good God, it was that long ago. His murder trial began on January 23, 2023. The presiding judge was the Honourable Clifton Newman. The trial ran for 6 weeks, ending with the convictions on the evening of March 2, 2023, and sentencing on March 3. The state rested its case in chief, and the defence began its case on Friday, February 17. The court was not held on February 20, which was President's Day. How is that relevant? After returning from its holiday, Miss Hill began to enter the jury rooms often. Oh, okay. So she had a weekend off, and then that's when she sort of decided to start influencing things. Maybe over the long weekend, someone said, hey, why don't you write a book? Affidavit of juror number 630 is attached to Exhibit A. As the defence began its case, Miss Hill told jurors, you all are going to hear things that will throw you all off. Don't let this distract you or mislead you. Additionally, Miss Hill and juror 826, the new jury foreperson, on multiple occasions, went to another room to have private conversations lasting 5 or 10 minutes. Sometimes they would go to the jury's single occupancy bathroom together. I'm sorry, what now? The foreperson never said anything about the content of those conversations to other jurors. Miss Hill even instructed jurors that they could not ask the foreperson about these conversations. 2 days later, on Thursday, February 23, and continuing through the next day, Mr. Murdaugh testified in his own defence. Before he began his testimony, Miss Hill told jurors not to be fooled by the evidence that his attorneys presented, which at least one juror understood to mean that Mr. Murdaugh would lie when he testified. Miss Hill also instructed the jury to watch him closely, to look at his actions, and to look at his movements.
So instructed is a really loaded term here under American law because normally it's a term of legal art. It's the instructions the jury are given to evaluate the evidence presented to them and arrive at a verdict. So they're given jury instructions.
Yeah, which should only come directly from the court.
Before the jury goes to the deliberations, the judge reads them a bunch of jury instructions and then they're given printed copies of those. Those are the kind of the rules, the algorithm, the computer program by which they're supposed to arrive at a verdict. So when they say that the clerk instructed the jury, the only person who gets to instruct the jury is the judge. Period. Period. There's no ambiguity there. When they say the clerk instructed the jury, they didn't pick that term instruction at random.
No, that's a very deliberate thing. Immediately after he testified, the foreperson, juror number 826, told the jury that he was crying on cue. She also criticised the former foreperson, juror 589, for handing Mr. Murdaugh a box of tissues when he was crying on the stand, because that is what the defence wants us to do.
Ooh, that's influence of a juror.
Yeah. The next court day after Murdaugh's testimony...
By the way, I
Monday,
think that juror got removed based on the allegedly fake Facebook posts. Also,
yeah,
put up
I'm pretty sure it was the former foreperson. So that's
So then the Judge Newman got to pick a new foreman.
Mm-hmm.
You think the foreman who handed Alec Murdaugh the box of tissues might have been more favorably disposed to the defense?
I think there might be a case for that. Okay, on Monday, February 27, Miss Hill told Judge Newman about a Facebook post that she purportedly saw the evening of Friday, February 24, the day that the testimony concluded, while perusing a Facebook page group called Walterboro Word of Mouth. Attached to Exhibit C. The post, purportedly by juror numbers 785's ex-husband Tim Stone, allegedly stated that his ex-wife was saying that she was on the jury and saying stuff about how the verdict was going to be. Oh, how her verdict. Hang on. No, it's a different juror. So the former full person is 589. The Facebook post was 785. I can't remember why the former full person would have been removed. Anyway, it's been that long ago. Judge Newman asked her to produce a copy of the posting. She could not produce a copy, but according to Miss Hill, a subordinate employee in the clerk's office, Laurie Weiss, discovered the post was taken down and replaced with an apology post that said, "Folks, I posted an ugly post yesterday, to which I've deleted, and I kinda, in a roundabout way, directed it towards a certain person, and would like to apologise to everyone who read it that ugly for me. To do that, and yes, I let Satan control me, and I broke down and started drinking, and when I was drunk, I made the post, I'm sorry."
Looks to be a complete fabrication, but we'll find out when we get the hearing and the subpoena and we grab her computer. We'll see what happened then.
Yeah, well. Rebecca Hill's behind the doors of justice. Timothy Stone's Facebook page at Exhibit E. The apology post states the initial post was already deleted on February 16, so it would have been impossible for Miss Hill to see the original post on February 24. Uh-oh, timeline's a bitch. Mr. Stone, juror number 785's ex-husband, avers in a sworn statement that he made no such post. Mr. Murdaugh has obtained an authentic download of the entirety of Mr. Stone's Facebook activity from January 23 to 2023 through to March 2, 2023, which confirms he did not post the apology. The supposed original post, if deleted, would not be recoverable at this point under Facebook's retention policies, and that he, in fact, never posted anything to the Walterboro Word of Mouth Facebook page during the trial. The person who made the apology post is an unrelated person, also named Tim Stone, whose Facebook profile picture is not Juror 785's ex-husband. How does that work? Did she just randomly type into the Facebook search bar, Tim Stone, hey, I need you to make a post for me?
The suggestion is that she made up the story about the first Facebook post, and then when she got called on it, she created a fake account with the same name and an arbitrary photo to do the apology post.
See, that's slightly worse than what I thought, in that maybe she just found another random drunk guy's apology post on Facebook from around the same time. She managed to get that lucky.
Think because the photo she used is not the same person as the actual ex-husband.
Yep.
So it's hard to imagine the actual ex-husband would create a Facebook account with a photo not his own to do an apology.
Oh, no, I was thinking maybe it was just a completely random other Tim Stone who was just being apologetic for something he posted on Facebook. And she's just taken that and shown it to the judge. But, yeah, her making a fictitious account is so much worse as well. On February 28, Miss Hill questioned Juror 785 about the fictitious post alone in her office in the courthouse. That's a no-no. She told juror number 785 that someone had emailed her stating that her ex-husband, Tim Stone, posted on the Facebook page, and that juror number 785 had been drinking with her ex-husband, and that while drunk, she expressed opinions on the guilt or innocence of Mr. Murdaugh. Juror number 785 told Miss Hill that that never happened, and that she'd not seen her ex-husband in 10 years. Juror number 785 asked to see the post, but Miss Hill would not show it to her. She directly asked juror 785 whether she was inclined to vote guilty or not guilty. Juror number 785 said she had not made up her mind. Later that day, Miss Hill told the juror that Sled and Colton County Sheriff's Office personnel went to Mr. Stone's house, and he confirmed that he made the post. She's just digging a 6-foot hole at this point, isn't she?
Well, you always get away with it until you get caught. It seems easy until people start looking.
This is a fabrication by Miss Hill. Miss Hill told juror 785 she would somehow reinstate a restraining order juror number 785 previously had against Mr. Stone, which was something Miss Hill did not have the authority to do. Still later that day, Judge Newman examined juror 785 regarding both the non-existent Facebook post and the tenant co-worker email in camera.
So it mattered, right? The judge was involved, so this mattered.
Yeah. Can't just say that this is inconsequential. Juror 785 described her interactions with Miss Hill regarding the Facebook post. She denied making any inappropriate comments about the case to third parties and stated she wanted to hear closing arguments before forming an opinion on Mr. Murdaugh's guilt or innocence. After she was dismissed, Judge Newman said, "Oh boy, I'm not too pleased about the clerk interrogating a juror as opposed to coming to me and bringing it to me. He was right to be concerned." Again, no shit, Sherlock. The next day, on the 1st of March, the jury visited Moselle, the site of the murders. During the visit, four-person juror 826 and Miss Hill walked off to have yet another private conversation. In her book, Miss Hill more vaguely hints at communicating her opinion on Mr. Murdaugh's guilt to the jury during the visit. While the jurors visited the Moselle property, we all could hear and see Alex's story was impossible. Some of us, either from the courthouse, law enforcement, or jury at Moselle, had an epiphany and shared our thoughts with our eyes. At the moment, many of us standing there I knew, and they knew that Alex was guilty. That day, Judge Newman also held an in-camera conference regarding the tenant co-worker email, in which he decided to revisit the Facebook post with Miss Hill. All right, how long is this? Do I want to... Yeah, okay, all right. Okay, well, let me see what Becky's talking about. I wanted to revisit the Facebook post that you mentioned yesterday. Right, that's Becky Hill, Court of the Clerk. Can you tell us about the Facebook post? Yes, I think it was Friday evening. Just for a brief moment, I perused Facebook, got onto the Walter Burrow word of mouth, and saw where someone had said that, well, it was the ex-husband of a juror, and he said that he noticed his ex-wife was saying that she was on the jury and saying stuff about how her verdict was going to be, and that he was the ex-husband and she was known for talking way too much. And then I just kept on scrolling because that was enough for me. I'd gotten enough. How did you determine what he was talking about? When I heard that there was an email on Monday, I figured the two went together if it was true. Bloody hell. Well, she's confirmed she has an ex-husband who she has 3 restraining orders out against. So, okay. So even if he had actually said that, not a hugely credible witness anyway. So when we looked on Monday after you told me to go and go back and look for it, and we couldn't find it, but then we found out his name and we found the post printed out where he said he'd put something up, but that he had deleted it at the time and he put stuff out there that wasn't nice. He said he got drunk afterwards, something about the devil. Didn't he say it was Satan in it? Satan was in it, yes, in all of the details. Oh, for crying out loud. Just wanted to get that on the record. You're reading a Facebook post by the ex-husband who said it. Of course, you haven't talked with him, so you don't know where he got the information from. I don't. I can find it, though. That's... okay. Miss Hill never saw any such Facebook post. She made it up. Further, she knew the apology post was not posted by Juror 785's ex-husband. Juror 785 showed Miss Hill a picture of her ex-husband, which was not the Facebook profile picture of the other Mr. Stone's post about Satan. The next day, the day of the verdict, juror number 785 received a call from her ex-husband that she did not answer. The call upset her because Miss Hill's lies had led her to believe he was posting on Facebook about her and might be stalking her. Juror 785 asked to speak with Miss Hill. She told Miss Hill she was scared, and Miss Hill told her that the Murdaughs probably got to him, meaning her ex-husband. I can't wait to actually look over this affidavit. I know it's relatively short, but if she actually swears to that.
I can't wait for Hill to be on the witness stand under cross-examination.
Did you say this? I plead the fifth. Did you say this? I plead the fifth. Did you... You're right. It's going to be fun.
So you can't tell us whether or not you said that or not? Nope.
No, because it would potentially self-incriminate if I said this. And it's, although you're supposed to take it as not being an admission, let's be perfectly honest.
In a proper court, there are no circumstances under which the court clerk should be pleading the Fifth Amendment. The court clerk's conduct should be so unquestionably clean that they have nothing to worry about.
Exactly.
In terms of criminal liability. And of course, technically, it won't be cross-examination because the state won't call this clerk as a witness. It'll be the defense. But she'll not answer, and then they'll say, Your Honor, we want the privilege to treat her as a hostile witness. And then it's cross-examination effectively. And she's just going to say the fifth. But I want that on the record. I want the appeals court to be able to see that.
Oh, absolutely. So on the day, she once again asked her opinion regarding the guilt. Juror 785 told her that Creighton Waters' closing was good, but that she still had questions. Miss Hill asked what questions, and Juror 785 replied she was concerned that no murder weapon was found. Miss Hill then asked, well, what makes you think he's guilty? Juror 785 said Paul's video at the dog kennels. That wasn't great. I still can't work out why he would have lied about actually.
That was not the time of the murder.
It's true.
So there's no evidence he was actually at the murder scene at the time of the murder. Of course, he lived there. He was there before. He was probably there after, but he was not there at the time of the murder. I mean, at least there's no evidence of it.
No, I just think he was just so used to lying that he didn't even think about it, and he got caught in it, unfortunately. What was that? Waters was on his knees for his part of his closing. Miss Hill then told the juror, number 785, that everything Mr. Murdaugh had said had been lies and that I should forget about the guns. They will never be seen again, because there was probably going to be a mysterious boating accident that involved... Oh, shit, I didn't think that one through. Miss Hill then asked for juror 785 about the views of the rest of the jury, telling her that if the foreperson would just go in and ask for raised hands, this would be over and done with, and everybody needs to be on the same page. Juror 785 went into the jury room. 10 minutes later, was excused from the jury. In open court immediately after her excusal, juror 785 asked Judge Newman if he had spoken with the clerk of the court, referring to the conversation earlier that morning with Miss Hill. Judge Newman responded, I have not spoken with her today, and that is totally independent of any conversation regarding her ex-husband, apparently misunderstanding her question to refer to the issue of the Facebook post. When the jury began deliberations that evening, Miss Hill told them that this shouldn't take us long, and that if they deliberated past 11 p.m, they would be taken directly to a hotel, even though none were prepared for an overnight stay. Okay, so the one juror that is possibly considering whether or not he's guilty or not and is on the edge is one of the...
ambivalent. Her opinion is being warped by the elected court clerk.
Well, it's not only that, and then all of a sudden she becomes an alternate and she's not on the deliberating jury.
Right.
So that's starting to smell a little bit fishy to me now too. Okay. When the jury began deliberations that evening, Miss Hill told them... Additionally, smokers on the jury asked to be allowed to take smoke breaks as they'd previously been allowed to during the 6-week trial. But Miss Hill told them that they could not smoke until deliberations were complete. There were 6 smokers on the jury. Literally, you've got 6 angry men and women because they can't have a puff of a smoke.
Right. They're literally drug addicts in withdrawal from their drug.
They would have been climbing the walls. Miss Hill told jurors that after the trial they would be famous and predicted that media would request interviews with them. She even handed out reporters' business cards to the jurors during the trial. Juror 578 took this to heart and made an appearance on Good Morning America the night of the verdict, which is why on the day the jury began deliberations, he wore a suit coat for the first time during the trial. He was prepared for his interview directly afterwards. That's hilarious. After the verdict, immediately before sentencing, Miss Hill pressured the jury to speak as a group to reporters from the network's news shows. She travelled with jurors to New York City, where they appeared on the Today Show. She got her book deal. Her book, Behind the Doors of Justice, was released on August 1, 2023. A last point about Miss Hill's efforts to promote her book shows her dishonest efforts to profit from the trial continued well after the verdict. A film crew negotiated a contract with Colton County Sheriff's Department to use courthouse bailiffs to provide security while they filmed a documentary about the county courthouse when it was closed for Confederate Memorial Day on May 10, 2023. The film crew had previously recorded an interview with Miss Hill. What the hell? On May 9, she sent a memorandum to the film crew purporting it to be an addendum to the contract. In it, she demanded that the film crew pay Colton County a fee of $1,000 per day for use of the courthouse facilities, and made a nonsensical statement about not having authority outside South Carolina reflects a failure to understand the choice of law clause in the contract. She then bizarrely added a handwritten demand. Also, in exchange for use of the likeness of Rebecca Hill in an interview, a minimum of 5 video second and audio clips will accompany the usage on first reference. The book cover for the book, Behind the Doors of Justice, The Murdaugh Murders, will be shown, and audio will include Becky's introduction as clerk of the court for Colton County and author of the book. Okay, that to me is... I'm not quite sure where the whole $1,000 per day fee came from. But that's... I can appreciate the entrepreneurial spirit there, but that's like dirty. Aussie is shocked by everything. No, not so much. It's not the conduct, it's the fact that it was so blatant. The film crew ignored her addendum as the contract had already been executed, but like her jury tampering during the trial, it was an attempt to violate the South Carolina Code, which provides no public official, public member, or public employee may knowingly use their official office, membership, or employment to gain an economic interest for themselves. Yeah. Okay, so legal standards, arguments, don't really care about any of that. Okay, so exhibits. Affidavit of the juror. Personally before me, who was first duly sworn, deposed and states, juror number 630 in the case of the state of South Carolina v. Richard Alexander Murdaugh. Screw it. Toward the end of the trial, after the President's Day break, but before Mr. Murdaugh testified, the clerk of the court, Rebecca Hill, told the jury not to be fooled by the evidence presented by Mr. Murdaugh's attorneys, which I understood to mean that Mr. Murdaugh would lie when he testified. She also instructed the jury to watch him closely immediately before he testified, including to look at his actions and look at his movements, which I understood to mean that he was guilty. Immediately after he testified, the foreperson, juror 826, said Mr. Murdaugh was crying on cue. The foreperson... Because the jurors aren't supposed to discuss any of this between themselves either until they're deliberating.
Well, in theory, yes.
Yeah, I mean, look, in practicality, we know that they do, but this is legitimately sounds like an attempt to influence. The foreperson, juror 826, criticised the former foreperson, juror 589, for handing Mr. Murdaugh a box of tissues when he was crying on the stand while testifying about his murdered son. She told the jury, "We cannot interact with Mr. Murdaugh because that's what the defence wants us to do." The jury frequently discussed the case during breaks before deliberations. Towards the end of the trial, Miss Hill came into the jury room a lot. Miss Hill and the foreperson, juror 826, had private conversations on multiple occasions. The foreperson would tell the bailiff that she needed to speak with Miss Hill. Miss Hill would arrive, and then she and the foreperson would go to another room and have a private conversation. The conversations typically lasted 5 to 10 minutes. The foreperson never said anything about the content of the conversations. For example, she never communicated logistical information after those conversations. This happened 2 or more times more frequently towards the end of the trial. When we began deliberations, Miss Hill told us that it shouldn't take us long, and that if we deliberated past 11 p.m, we would be taken directly to our hotel. We had driven from our homes that morning and were not prepared for an overnight stay. Additionally, smokers on the jury asked to be allowed to take smoke breaks, but were told that they could not smoke until after deliberations were complete. I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by the other jurors. After the verdict and immediately before sentencing, Miss Hill pressured the jury to speak as a group to reporters from the television show... whatever the hell that was. Okay, and so... Affidavit of H. Miller, 741. Okay, so this is the other affidavit. On August 6, 2023, Dick Harpootlian, Jim Griffin, and I met with Juror 741 in the case of the state of South Carolina v. Richard Alexander Murdaugh at her home located there. At the meeting on August 6, they indicated that she would sign an affidavit. However, we were unable to arrange with her a suitable time or place. During the meeting, she relayed the following information to us. During the trial, she witnessed the clerk of the court, Becky Hill, come to the jury room, and Miss Hill and the foreperson went into the bathroom. After Miss Hill and the foreperson exited the bathroom, Miss Hill told the jurors that they could not ask the foreperson questions. Several times during the trial, Miss Hill told the jurors that the media would want to interview jurors at the end of the trial, and during one of these conversations, she passed out business cards from the media to the jurors. At the end of the trial, she told the individual that no one from the media wanted to interview her. Interesting. Right before the defense put up their case, Miss Hill told the jurors, "You all are going to hear things that will throw you off. Don't let that distract you or mislead you." After Alex testified, 8 jurors indicated that they did not believe his testimony. Juror 544 was very emotional during the trial. During the visit to Moselle, juror 826 and this individual walked to the scene together. Then juror 826 began walking with the clerk of the court. There were times the jurors were not kept together, and they were in 2 separate rooms. They noticed that jurors talking about the case before deliberations began. Neither she nor the other juror 785 joined in on the conversations about Alex. As the jurors were deliberating, she believes Judge Newman came to the room that she was in and told her the jury would have to spend the night in a hotel if they did not vote by a certain time, but she does not recall the time deadline. Is it usual for the judge to be doing that? Surely the clerk should be the one passing on that information.
The information of what?
Well, she's saying that it was the judge that came in and said that if they didn't reach a conclusion of the deliberation, that they'd go to a hotel.
Well, the judge makes the decision. So, I mean, sometimes he passes that order on to the clerk, and the clerk passes it on to the jury. But it's not uncommon for the judge to speak to the jury directly about that kind of gross stuff. Like, you're not going home tonight. You'll be in a hotel again.
Right. Okay. Generally, here we wouldn't have the judge interacting directly with the jurors once they're deliberating. So it was just curiosity for me.
I see. Yeah. So it's not a material fact in the case, right? It's just administrative where they're staying for the evening. So it's not that big a deal. If the judge were going to change a jury instruction or clarify some piece of evidence or provide access to a piece of evidence, then it becomes more formal. The counsels have to be involved and so forth. But in terms of like, are you going home or are you going to go back to the hotel for the night? That's the judge will just do that at his discretion.
Okay. All right. Okay. Juror 741 was the first former juror to provide information that occurred. The clerk of the court made statements to members of the jury about evidence presented during the trial. Prior to jury deliberations, Miss Hill's conduct was corroborated by other jurors during subsequent interviews. And they got transcripts. Okay, that's just the transcript from the court for when she was talking about the Facebook post. So this is the book, supposedly. Why are they... What are they showing there? Sunday night after Alex was sentenced, I accompanied 3 jurors from the trial to New York City. As I mentioned earlier, Craig Melvin and Savannah Guthrie of the Today Show interviewed the 3 jurors during a 7-minute high-energy segment.
Okay. I'm sorry, but the jurors are going to they're leaving South Carolina. They're flying to New York City to be interviewed by the media, which is fine, I guess. That's allowed. Why the F is the court clerk accompanying them?
No clue.
Would the stenographer accompany them? Would the courtroom bailiff accompany them? I mean, this is ridiculous.
Well, at this point, I wouldn't be surprised if the stenographer was the one that typed out the damn book for her. While we were in the Today Show green room, we met and took photos with country music star Dustin Lynch, who was also getting ready to appear on the program to sing one of his songs. Once the taping of the Today Show concluded, we were whisked away from the 850-foot skyscraper building by a driver in a black Chevy Tahoe.
Look how she's aggrandizing it, right? It's an experience for her. The skyscraper was this big. We were whisked away by a limo. This all goes to bias.
So they were whisked away to where Dateline tapes their segments. What stuck out to me was that one of the jurors mentioned to a producer that she had a craving for pizza and cheesecake, and the next thing you know, both were delivered in time for lunch. Oh, for God's sakes. The trip was extra special for me because it was my first time ever flying in an aeroplane. Oh my God. Okay, hang on. So this is stuff about the jurors. Working with jurors.
I mean, I guess they could have put her on a Greyhound bus and stapled a couple of wings to the side of the bus, and she wouldn't have known the difference.
Oh, this is interesting. She's criticizing the jurors. Whilst most of the jurors were focused and engaged during the Murdaugh trial, we did have one juror who was an alternate at one point who was not. She was more focused on the crowd who was watching who was or wasn't following Judge Newman's rules and so on.
Is that the person she got rid of?
Probably.
Is that her motivation?
For example, she caught a new visitor to the courtroom who was sitting directly across from her, who looked like she may have been taking a photo of the jury, and that wasn't going to fly with her. I'm sorry, is that not okay for a juror to not want their details released prior to the court case ending?
Correct. Absolutely. Within the juror's privilege, they're told their identity will be protected for some period of time after the verdict.
Apparently another juror moved around and would squeak in the chair. Then there was the egg lady juror. The juror worked on a monkey farm in the Low Country, and she drove Judge Newman bananas one weekend, pun intended. Oh God! Through the
that's
Facebook
so
page,
inappropriate. She drove the black judge bananas. That doesn't seem right. You people are terrible.
Through the Facebook page, about 20,000 followers saw the juror's ex-husband post about how she was talking way too much to her friends and family. about the case. Many people became aware of the situation after court on Friday, February 24, when it was brought to the attention of Judge Newman. I typically didn't have the time or energy to watch any media coverage of the trial, but on that Friday night, I was scrolling through the social media feed and saw the post from the ex-husband, but he didn't mention the juror's name or her juror number. Yeah, I call bullshit.
Can we agree this is basically not 50 Shades of Grey?
Yes. At the time, I didn't think anything of it and kept scrolling. Okay, we already know that's bullshit because the way that she acted when she brought it up to the court. Mainly because I've been inundated with emails and messages from people all over the world about what they had heard, what they'd seen, how the prosecutor and defense should run their cases, how Judge Newman should rule, and what to address with anyone and everyone involved in the courthouse and so on. One of the other jurors raised... Hang on, so this is the egg lady. Oh, this is the one that got removed because she went back because she said she had to pick up a dozen eggs that she left in the jury room. After Judge Newman interviewed the juror, corroborating witnesses about the situation, he removed the juror from the jury. We later learned that the ex-spouse hadn't seen each other in 14 years, and the former juror had 3 restraining orders against her ex-husband. When the juror is removed from the jury, it's normal practice for the judge to ask if there are any personal items. She just wanted her eggs, which caused some laughter in the courtroom, and nationally, once the media got a hold of it. What a crock.
Yeah, it's same old story. Modern women desperately looking for their eggs.
Okay, so this is supposedly the post that was left. Folks, I posted an ugly post yesterday to which I deleted, and in a kind of roundabout way directed it towards a certain person. I'd like to apologize to everyone who read that ugly for me to do that, and yes, I let Satan control me and I broke down and started drinking. When I was drunk, I made that post and I'm sorry. A whole bunch of people replying to it, just saying that he's human, whatever else. Yeah, okay, here's his affidavit. I did not post anything on the Facebook group between January 23 and 2023 and March 2, 2023. Did not post anything on social media or my own Facebook social media page about ex-wife being a juror and that they were talking too much to family and friends about the case, or that Satan had got on a hold of me and I'd been drinking at the time that I posted and was now very sorry. He very clearly wanted to get it on the record and clear his name about that.
Or somebody did.
Oh no, I mean, like he's
because
put it specifically in the affidavit.
The allegation of the defense is this was a fake account.
Yeah,
that the court clerk did this.
Nor did I post what is attached as Exhibit A, which has been represented to me to be the alleged post, and to the court exhibit. Okay, so hang on. Oh, that was Did not have a Facebook page set up. Oh, Mike Sullivan. On behalf of myself and the rest of South Carolina, glad you and No Tie Prank are enjoying our culture.
I like South Carolina. I really do. I've been there. I like it. I just wouldn't want to be a criminal defendant there.
Well, I'm not going to lie. It gives me pause as to whether or not I would want to travel through it, to be perfectly honest. But
I would.
I'm sure it's a lovely place. I was never contacted by law enforcement, the South Carolina Attorney General's office, the clerk of the court, or anyone at the Colton County Clerk of the Court's office about Exhibit A, or a post on the word of mouth Facebook page concerning my ex-wife. So this is him swearing that no one contacted him, despite the fact that in her affidavit, the ex-wife is saying, well, the court of the clerk said that law enforcement had already contacted the husband and that there was issues there as well. So, I did not know that she was on the Murdaugh jury until I heard her voice in a recording when she was being excused as a juror and she was discussing something about eggs. Okay, so that's the same post. Okay, so this is one of the attorneys at Harpootlian's office. On August 18, 2023, I met with Tim Stone at his home, provided me his Facebook login information, allowed me to download a copy of his Facebook activity from January 23 to 2023 to March 2. True copy of the download is attached at Exhibit A. The contents of the download speak for themselves, but a review of them shows that no posts made from February 16, 2023, apologizing for a previous post. There are no posts whatsoever to the Facebook group Walter Burrow Word of Mouth. Facebook's stated retention policy is deleted posts is 30 days, so any posts deleted in the period between January 23 and March 2 will not be recoverable. Okay, so this is juror 785. Okay, here we go. Juicy. Hopefully. During the presentation of the defense case after President's Day, but before Mr. Murdaugh testified in his own defense. Hang on, is this the one that I already read? No? Okay. Rebecca Hill told the jurors not to be fooled by the evidence presented to the jury by Mr. Murdaugh's attorneys. In late February, she questioned me about a Facebook post to the Walterboro word of mouth page. She summoned me to speak with her alone in her office at the courthouse. She told me someone emailed her about a post that my ex-husband, Tim Stone, purportedly made, which purportedly stated that I made comments to him about the guilt or innocence of Mr. Murdaugh. She directly asked me whether I was inclined to vote guilty or not guilty. I told her I had not made up my mind and wanted to hear all the evidence before deciding.
None of this is even vaguely within the province of a court clerk. For those who don't know, court clerk is a purely administrative. I staple papers. I organize shit. I make the phone call for the sandwiches to be delivered to the jury. It's a very secretarial type of position. There's no authority there. The court clerk,
which is ironic, given you've got to be elected to the position.
Anything.
So, yeah. Ms. Hill said the post said that I had been drinking with my ex-husband and that while I was drunk with him, I expressed opinions about the guilt or innocence. That never happened, and I told Ms. Hill that it never happened. I did not go drinking with my ex-husband. In fact, I had not seen him in approximately 10 years. Yeah, so this is prior to her talking to the judge. Hills called the juror into her office, and she said to her, no, I haven't seen my ex-husband in 10 years. And she still went ahead and put it to the judge that this was all purported. Far out. I asked to see the post, but Miss Hill would not or could not show it to me. I've never seen it, and to my knowledge, no one has. Later that day, Miss Hill told me Sled and Colton County Sheriff's Office personnel went to my ex-husband's house, and he purportedly confirmed he made the post. She told me she would reinstate a restraining order that I previously had against my ex-husband. Yeah, so you've got Hill deliberately telling her that she's interacted with the ex-husband, and the ex-husband said, nope. No one even remotely has contacted me. I don't think Miss Hill got the memo she had no power, feelings of grandeur. Maybe. I did not know about the apology post referring to Satan until Miss Hill's book was published. I've since reviewed that post and can definitely state that the post is not by my ex-husband. He does not go by Timothy. The profile picture is not him, and the phrasing of the post is not phrasing he would use. It appears to be a post by another person who happens to have the same name. It does not appear to be the post on the Walterboro Word of Mouth Facebook page. When Miss Hill first asked about the Facebook posting purportedly made by my ex-husband, I showed her a picture of my ex-husband. For that reason, I now believe she knew that the apology post referring to Satan was not posted by my ex-husband. On March 2, 2023, the day of the verdict, I received a call from my ex-husband as I was getting on a bus to travel with the rest of the jurors to the courthouse. I did not answer. The call upset me greatly, and I asked to speak with the clerk of the court, which I did by telephone using bailiff Mr. Bill's phone. I told her I was scared, and she said that the Murdaughs probably got to him. Miss Hill then again asked me questions about my opinion regarding Mr. Murdaugh's guilt. She asked if I was leaning one way or the other. I told her that Creighton Waters' closing was good, but I still had questions. She asked me what kind of questions, and I replied questions about the guns. She asked what would make me think he was innocent. I stated that no murder weapon was found. She then asked, well, what makes you think he's guilty? I said Paul's video at the dog kennels. She then stated that everything Mr. Murdaugh had said had been lies and that I should forget about the guns. They will never be seen again.
All that is so inappropriate, it's unimaginable. So, of course, the legal question is not, do you think he's innocent? Do you think he's guilty? The question is, do you believe the state has proved him guilty beyond any reasonable doubt? That's the legal question.
Which, of course, she didn't. Miss Hill then asked about the views of the rest of the jury, which, again, is entirely inappropriate. She told me if the foreperson would just go in and ask for a raise in hands, this would be over and done with. She said everyone needs to be on the same page. She then again said she would reinstate a restraining order I previously had against my husband, and that she would call Judge Newman about the restraining order. So on the one hand, she's saying, oh, I'll get it reinstated. On the other hand, she's sort of admitting she doesn't have the authority to get it reinstated. But anyway.
So it's funny because I have to say it's really offensive to me that she went in and told the jury, hey, if you just find him guilty, you get to go home right away. Right? You don't have to stay here and deliberate. It's all over. Just find him guilty. Having said that, and I do think that's inappropriate because I think the standards for what the state can do and what the defense can do are different. I have more than once told the jury, hey, if you find my client acted in self-defense, you get to go home. It's all over.
Yeah, but that's a bit different doing that in closing arguments compared to someone doing it
Right.
out
The
of...
cleric should never have anything
No.
like that to say about
No.
anything. Right.
I then went to the jury room approximately 10 minutes later. I was excused from the jury. During the proceedings, I asked Judge Newman if he'd spoken to the clerk of the court. He said he had not, that this is not because of your ex-husband. 2 weeks later, I did answer a call from my ex-husband. I angrily confronted him about the post that he purportedly made because I knew I had not made the comments he claimed I made. He emphatically denied ever making any such Facebook post and genuinely seemed to not know what I was talking about. On one day during my jury service, approximately 1 or 2 weeks before the verdict, Juror 864 and Juror 826 were in the single toilet unisex bathroom together for an extended period. They were known to do so frequently to discuss the case.
Or whatever reason.
Juror 729 referred to it as the A&D time. In the van going to the courthouse, Juror 864 said Special Agent David Owen lied on the stand, but that nothing would happen to him. When we visited the Moselle crime scene, Miss Hill and Juror 826 walked off together, avoiding other jurors in order to have a private conversation. I own a rental property which was leased to 2 tenants, Deborah Webb and Clifford Dandridge. On Saturday, February 18, 2023, I delivered a refrigerator to the property. This better be relevant. What the hell? I was removed from the jury on the day of the verdict because a co-worker of Miss Webb purportedly said I expressed an opinion on Mr. Murdaugh's guilt or innocence while delivering the refrigerator. Miss Webb then worked at Domino's Pizza in Walterboro, so the co-worker would be some employee of Domino's Pizza in Walterboro. I do not know whether Miss Webb actually made any such statement at Domino's Pizza or whether a co-worker actually heard any such statement. But did you make the initial statement that may have been then passed on and overheard? Still not a good look. After I was dismissed from the jury, I spoke with Miss Webb and Mr. Dandridge, who both vehemently stated to me and my husband that the affidavits the prosecution drafted for their signature was not what they had said to him.
Ouch.
They told... Yeah. They told me Sledge showed up at their home at 10 p.m. after they were asleep, removed them from their home, put them in separate cars, and questioned them. Nothing unusual about being manhandled into the back of a car, separated from your partner. Mr. Dandridge said he told them I did not say anything about Mr. Murdaugh's guilt or innocence. Sled returned 30 minutes later, again woke them from their beds to serve subpoenas on them to appear in court the next day. They arrived at the courthouse at 9 a.m. the next day and were held for 9 hours until 6 p.m. when Sled officers or a prosecutor finally presented typed affidavits to them, saying that they were statements from the previous night that had been recorded on dash cams in the patrol car. They said they signed the affidavits without reading them. Don't do that, people. A, if you ever find yourself in the back of a police car, keep your mouth shut. But B, never sign anything without reading it. I mean, come on.
But it happens. It happens all the time, right? The cops just say, "Hey, just sign this. It's your release form. Just sign this, and you get to go home." And you're like, "Oh, my release form. Okay, I'll sign that." You don't even know it's an affidavit.
Nope.
It's terrible. But you're absolutely right, man. Listen, if the cops have grabbed you, they're telling you can't leave. Shut your dirty mouth. You got nothing to say. Anything you say is more likely to hurt you than help you. And if they ask you to sign something, you lost control of your hands. You cannot work a pen. Nothing works. Sit in that jail cell until a lawyer that you're paying shows up to represent you. The sitting in the jail cell, I know it's horrible. It feels horrible, folks. I get it. If you're a normal law-abiding person, you've never been in an interrogation room or a jail cell before. Let me tell you, man, compared to life in prison, it's nothing. It's an interesting cocktail story you'll tell later on in life. Just keep your mouth shut.
Exactly. As I previously testified, I never discussed the merits of the Murdaugh case with Miss Webb, Mr. Dandridge, or any other person present, nor did I express an opinion on Mr. Murdaugh's guilt or innocence while delivering the refrigerator or during any interaction with them during the trial. Transcripts, don't really care so much about that. Is there any other affidavits? H. Miller. Okay, so this is the lawyer again. They met with Juror 326 in the case of the state of South Carolina v. Murdaugh and his mother at her home located at such and such. During the meeting, juror 326 relayed the following information. He was asked if Miss Hill had told the jurors not to let the defense mislead them. He did not specifically recall his statement, but he did recall that Miss Hill commented to him and other jurors about the photos that would be admitted into evidence, indicating that the images would be disturbing. Juror 326 also stated that the jurors were stationed in 2 separate rooms when they were not in the courtroom, and that he was in a room with mostly other male jurors. He was not in the same room as jurors 630, 741, 785. Juror 326 stated that Miss Hill would visit the other room more often, and that he could not hear what she was telling the jurors in the other room. During the trial, Juror 326 and others discussed the case prior to deliberations. He did not discuss the case with anyone outside the jurors. He further commented that some of the jurors were going into their office because of financial reasons, and that people were talking to co-workers because co-workers wanted information. Before deliberations began, he indicated that a minor conversation led him to know who was a yes and who was a no. His vote changed with new evidence. As the jury was deliberating, the bailiff and Miss Hill told the jurors that they could not take a smoke break during the deliberations. There were 6 smokers on the jury. After the trial concluded, a group chat was formed with the jurors, but juror 326 dropped off of the group chat because there were too many chats. When asked if he thought the clerk of the court, Becky Hill, was inserting herself into the process of the trial, he responded, "I can see this." Good on you. Oh, her memorandum. Okay. Stingy, 3 months from my free koala shirt. You'll get there, Stingy. Looking forward to your upcoming docuseries about the Murdaugh case, and I hope you'll be able to use some of my interviews should you choose to. Because I'm an elected official, we'll need to modify 3 clauses in the location agreement you presented to me as it relates to my authority. Please change the word owner to Colton County in every reference in the agreement. Low County Story LLC agrees to pay the Colton County Treasury a fee of $1,000 per day for the use of the Colton County courthouse facilities, as long as it does not supersede any court proceedings. Payment may be made to the close by the close. Will be made by the close of production.
Who's writing this?
This is the court of the clerk
portion.
Yeah. So she's also handwritten stuff down here, but so this is the email she sent off to the people that were making the documentary series. And she's basically saying that there's a fee for $1,000 per day payable to the county treasury for them to record inside the courthouse.
Which is just worse, actually. So she's in charge of the financial burden the documentarians have. And of course, she's getting paid for her part of the documentary.
Yeah. Colton County, South Carolina can only enter into a legal agreement for services if it is governed here in South Carolina, not New York. As an elected official, I have no authority outside the state of South Carolina. You don't say. Also, in exchange for the use of the likeness. Oh yeah, this is them. This is where she says that she wants her book to be shown as part of the docuseries. Basically saying you must show the cover of my book and you must introduce myself as the clerk of the court, clerk of the court, and I want to make sure that everything here is. I want to grandstand as much as possible to sell as many of my books as possible.
There's a personal financial interest. It's not just in the public interest of news and media and understanding what happened in the trial. I am going to make money from this transaction.
Yeah. Far out. She's really dug herself a hole here. Like this is. You hear about corruption, you imagine corruption, and then you see shit like this. And did you just think you wouldn't get caught? Like, both literally and figuratively? So,
that's exactly what she thought. Of course.
She had to have. She had to have thought that she was too far above it.
This is probably the norm.
That's actually a really scary thought, because that means what other cases has she done this on? Like, what other cases she influenced juries? What other... how many other potentially innocent individuals are sitting behind bars right now because she influenced a jury?
And she's only been in the job a couple of years, but what made her think this was appropriate? Presumably all the other courts of clerk.
Yeah, probably the training or whatnot. Like,
why would you want that job? You have to run for election. It's just not randomly handed to you. You have to seek it out. Why would you want that job other than you believe there's some benefits you can get from the job? Well, is this the benefits she expected to get? So
what do you think? Do you think they'll get an application for a retrial out of this?
I don't know. It's so
I know, I'm
political at
still
this
on the-
point. It's not really based on legal merit. On legal merit, should there be a new trial? Absolutely. The
Yeah.
legal standard under South Carolina law is simply whether or not an elected officer under color of law, spoke to the jury about material facts outside the environment of the courtroom, which clearly happened according to these affidavits. So if you believe the affidavits, the four sworn affidavits by the jury, that happened. And South Carolina law says if that happened, we're simply going to presume that there was reversible prejudice against the defendant, because there's no reason for that to happen. So
No.
that's a new trial. Now, of course, it's going to go back to Judge Newman to hear this. He's going to hold the evidentiary hearing. He has to decide whether there should be a new trial. And if there's a new trial, it would be presumably be in his courtroom. So you wouldn't expect it to be that much different unless they manage to get the venue of the court removed somehow.
I think you'd have to. You would have to swing for the fences on that one, because I mean, at this point, you're right. It goes back before Newman. I would think that as an objective observer, that he may even have a personal interest in making sure that this gets swept under the rug, because it is the
even
court,
if you
clerk
don't
of his
know,
court.
there's at least an appearance of impropriety, right? There's
Exactly.
at least an appearance, a scent. There's a bad smell.
Mm-hmm. So, and yeah, the retrial most certainly should not go before him. But yeah, so basically, guys, that's what I had on the Murdaugh stuff. I wasn't sure, Andrew, if you wanted to stick around. I'm going to have a look at a Gosney sent me details about a death penalty case that's starting tomorrow, and I just wanted to have a look in the background, see whether or not it was something that was worth following or not. But I wasn't sure what your timing was like.
Yeah, I will leave you to that. So I have to go and do stuff with the family. Thank you so much for having me on. It's always appreciated. Folks, don't go anywhere. Just because I'm leaving, you should not leave. I'm sure this will be a great show. Gosney always does great stuff. But Aussie, thanks so much for having me on. Everybody, have a great rest of the week, and I'll talk to you all soon.
Thanks very much.
Take care.
Cheers. Okay, where are we? So that means I can do that. Okay. So I woke up to an interesting message this morning in my tweets from Twitter message. Anyway, from Steve basically saying, "Hey, you might want to have a look at this case. They were doing jury selection today. Here's a link to it." I didn't know any of the real details about it, so I thought maybe we could have a look at it, see if it's something that we wanted to actually follow as a trial. And then I kind of looked at the background of it. And yeah, let's have a look, shall we? Accused Daytona Beach cop killer Othel Wallace to go to trial next week. This was last week, because all the news articles that I could find today were all about the jury selection, and I wanted something that actually had details about the case. So let's have a look.
Police officer begins on Tuesday. Othel Wallace is accused of shooting Officer Jason Rayner less than 2 months later. As West 2's Claire Metz reports, the trial will not happen in Volusia County due to pre-trial publicity.
You see? It's not that difficult to have a trial moved because of publicity. Like, stop it, Forbidden Ruin.
It's an inflammatory statement.
On and off for weeks now, prosecutors and defense attorneys in the case of accused killer Othel Wallace have been before the judge that will hear this high-profile case, working out details, arguing use of evidence. And now, in just a few days, the trial begins. Months ago, the defense team requested a change of venue because of all the publicity surrounding the case, and Judge Raul Zambrano granted it. But first, he took some time to consider another location, find out where the trial, expected to go at least a month, could best be accommodated.
Okay, a month-long trial. We'll see. I might do like roundups on it then.
He settled on the Clay County Courthouse in Green Cove Springs, about 80 miles north of Daytona Beach. Officials have said Officer Jason Rayner was on proactive patrol the night of June 23, 2021, when he drove behind an apartment complex on Kingston Avenue where Othel Wallace was sitting in his car.
Why have you got a hand on him?
Wallace lived in the complex. There was a confrontation, and Wallace allegedly pulled out a gun and shot Officer Rayner in the head. Officer Rayner died in the hospital August 17th. Othel Wallace was quickly identified as the suspect, and a massive manhunt led police to a rural property in Georgia days later, where Wallace was found.
Oh, yeah, that's the other thing that we got to add to this. I completely forgot about that. He ran to a paramilitary organization. Hang on, wait, I want to get the exact wording. Crap. So, officer shot while on patrol, passes away. That's the court. That's the. Where are we? Prosecutor seeks death penalty for alleged cop killer who ran to black nationalist paramilitary organization property after shooting.
Found hiding in a treehouse. Prosecutors say Wallace made incriminating statements and that items found inside the treehouse include the alleged murder weapon.
There's a charge of first-degree murder.
Othel Wallace is charged with premeditated first-degree murder of a law enforcement officer. Prosecutors are seeking the death penalty if Wallace is convicted at trial. Judge Zambrano has said he hopes to have a jury seated at the end of the first week. Claire Matz, Wesh 2.
Yeah, well, I mean, the jury selection went through today. It looks like they've impaneled them, so the trial itself will probably start tomorrow. So, I mean, look, this could be quite interesting. Where are we? So that's Law and Crime's take on it. Officer shot while on patrol passes away. With his family's blessing, we regret to inform you that the Daytona Beach Police Department officer who was shot nearly 2 months ago has succumbed to his injuries. Officer Jason Rayner passed away at 8:09 this evening on August 17, 2021. So this one's actually been going for like 2 years at Halifax Health Medical Center in Daytona Beach with his family by his side. Now more than ever, we ask for all of you to embrace the Rayner family and the Daytona Beach Police Department in your hearts during this devastating time and pray that God will give us strength to persevere through this senseless tragedy. Jason's sacrifice will never be forgotten. Excuse me. On behalf of the family, Chief Young thanks everyone who has shown their love and support. He's now asking for the public, including members of the media, to respect their desire for privacy while they grieve, of course. Officer Rayner became the 10th DBPD officer to fall in line of duty. Prior to that, the last officer to lose their life from injury sustained while on patrol was Kevin Fisher in 1998. That sucks. So, where's the Law and Crime article? Okay, so prosecutor seeks death penalty for alleged cop killer who ran to black nationalist paramilitary organization property after a shooting. Prosecutors in Florida announced plans to seek the death penalty against a defendant who allegedly shot a Daytona Beach police officer in the face on June 24. The officer, Jason Rayner, died on Tuesday evening. His department announced on Tuesday in connection with the family, so this is quite old. Officer Rayner passed away. Already read that out. The authorities caught defendant Othel Wallace in June after a manhunt led to a treehouse in Georgia. The treehouse was on a property associated with the Not Fucking Around Coalition, which Young describes as a black nationalist paramilitary organization at the time of Wallace's arrest. Wallace appeared in court for a few brief moments on Wednesday afternoon for an initial appearance. Questions surrounded whether he wished to hire private counsel or be represented by a public defender. Dude, you're on trial for murder of a cop. All due respect to them, do not take a public defender. Court records indicate that his request for a public defender was granted because he was deemed to be indignant. He's now charged with first-degree murder. He was initially charged with attempted first-degree murder. Prosecutors changed the charge less than a day after the death. Well, that's sort of what you would expect. Video released by the police back in June captured the sound of the shooting and the images of what led up to it. Authorities say Rayner was investigating a suspicious incident after neighbors were complaining about gun violence, drug sales, and everything else in the area. The body cam video indicates that Rayner approached an individual in a grey SUV and asked him if he lived at the address where the vehicle was parked. The individual, allegedly Wallace, got out of his car, argued with Rayner, and pulled the trigger. Damn. Come on now, Wallace asked Rayner when Rayner was trying to ask him questions about his residence. Don't do this. Why are you asking me if I live here? What's going on? Court documents indicate that Rayner was shot outside an address in Kingston Avenue. A witness who lived in the apartment at that address, Taisha Lewis, told a detective in a sworn interview that Wallace was her boyfriend and that the two had been dating for 6 years. She said Wallace lived with her and that he drove a grey Honda SUV, exactly the type of vehicle from which Rayner's attacker emerged in the above body camera video. Rayner's handcuffs were used to secure Wallace when federal, state, and local authorities caught him in Georgia. I'm unsure if that's actually, like... Okay. Ms. Lewis stated that she left the apartment at 4 a.m. to go to work, and that Mr. Wallace was in the apartment when she left. Ms. Lewis stated that when she returned home at approximately 5:20 p.m., Mr. Wallace was not in the apartment. Ms. Lewis stated that she heard a commotion coming from outside. When she went outside, she saw that an officer had been shot. The detective showed Ms. Lewis a photograph of the front of the vehicle as captured by the body-worn camera, and she identified the suspect as being her boyfriend, Othel Wallace. Ms. Lewis then began to cry and stated that her children would never see their father again. Ms. Lewis stated that Mr. Wallace is known to carry a handgun on his person and that Mr. Wallace also owns a rifle. Okay, so that's the statement. What's here? Charging documents and subsequent press release. Oh, it's actually loading. Officer from Daytona Police Department responded to the rear of the address in reference to an officer down. This detective also responded to the scene. Upon arrival, it learned that the victim, Officer Justin Rayner, a sworn law enforcement officer with the Daytona Beach Police Department, had been shot at least one time in the face. Responding officers found Officer Rayner's handgun holstered in his duty belt. Officer Rayner was not able to provide any information about the incident. He was transported to Halifax Hospital and is currently in critical condition. Body-worn camera captured the incident, showed the officer walk up to the vehicle in the rear, said the vehicle is a grey Honda SUV. Officer Rayner made contact with a black male wearing a yellow shirt and asked him if he lived at the complex. Black male exited the grey Honda SUV and would not sit back down in the vehicle despite requests to do so. Black male failed to follow a lawful command and began to struggle with Officer Rayner, then a gunshot was heard. This detective conducted a sworn interview with Taisha Lewis. Pay the fine, that's terrible. Miss Lewis stated she had left the apartment. Okay, so that's just all going back through there. Yes, getting shot in the face does sound awful. Sorry, ladies. Okay, images from the initial appearance via screen grab from the court pool. Okay. So there we go. So that one's going to be interesting. I will have a look, see whether or not we can squeeze a month-long trial in. Maybe, maybe not. We will definitely see. But yeah, thanks, Steve, for the tip-off. It's at the very least, I will look through and see what the sort of... At the very least, we'll watch opening statements. We'll get a feel for the case, see whether or not it's something we want to pursue or not. But, yeah. Guys, that's pretty much everything that I had set up today. As I said, I was running apocalyptically late today, so I don't have any news articles or anything. I very much want to thank Andrew for dropping by. Given we're in the time zone-ish, I might actually be able to have him on as a guest a little more frequently now that I think about it. But, yeah, as always, people, please remember, you are not a piece of shit. You do have value and you do contribute to society, especially when you hit that like button and double-check whether or not you're subscribed. And if you're not already, go and follow me over on Twitter. I am trying to put out as many shorts and whatever else here on YouTube, on Twitter. Videos are going out on Facebook. Really want to try and build up the community. So, but as always, stay healthy, wealthy, and wise, and I will catch you on the flip side. Cheers, guys. And where's that?
This shit, I'm out. Fuck this shit, I'm out. No thanks. Don't mind me. I'ma just grab my stuff and leave. Excuse me, please. Fuck this shit, I'm out. Nope. Fuck this shit, I'm out. Alright then. I don't know what the fuck just happened, but I don't really care. I'ma get the fuck up out of here. Fuck this shit, I'm out.